I am Pratyush Kumar from National Law University, Delhi. Today I shall be speaking on the module Originality Requirement in Copyright Law. Originality requirement in copyright law shall cover issues of its meaning, its nature, what are the requirements which would determine originality, what are the different tests determining originality, what is the quality of work irrelevant, what are derivative works, what is the sweat of brow doctrine, what is creative standard doctrine, what are FIEST publications, and what is the position in our country, India, and I shall conclude thereafter. To begin with, introduction. The term copyright can be literally construed to mean something as simple as the right to copy. Before the invention of the printing press in the 15th century, the need for a law protecting the copying of books or manuscripts did not arise because of the arduousness involved in manually copying a book. But soon, with the invention of printing, the need for a law prohibiting unauthorized printing, sale, or import of a book arose. And in England, a series of law, ordinances, bylaws, acts, etc., were passed to cater to this need. The Licensing Act 1662 is the first statute that expressly mentions inter alia that the ownership of a book or copy thereof by the owner to be a common law right. This finds a clearer interpretation in Lord Justice Mansfield's words in Miller versus Taylor, where he says, "Because it is just that an author should reap the pecuniary profits of his own ingenuity and labor, it is just that another should not use his name without his consent. It is fit that he should judge when to publish or whether he will ever publish." So the key words essential here are ingenuity and labor. How important are these words to the establishment of copyright over a copyrightable work will be seen in the following paragraphs. What is the meaning of originality? Isaac Newton once wrote, "If I have seen further, it is by standing on ye shoulders of giants." True to the very spirit of the statement, there is no work, literary, musical, or artistic, which can be said to be completely novel or unknown to mankind. The ingenuity of an author lies in his expression of his own ideas. In other words, the way in which an author chooses to arrange the known forms of expression, words, musical notes, objects, et al., is unique for each author, and that uniqueness is what we call originality. The first hurdle that a work has to cross to be copyrightable is the test of originality. To comment on the appropriateness of this test, one has to go back to the common law approach to copyright. The key words, as were earlier pointed out, were labor and ingenuity. According to Lockean theory of property, the rationale behind providing an author with copyright over his/her work lies in the labor that the author puts in making the work in its present form. Another important theory of intellectual property worth mentioning here is the personhood theory. This theory states that when a person works on anything, he expresses his personality on that subject. So, as humans in themselves are in possession of their person, so by extension they should also be the owners of subjects or objects they have worked on, as they become extension of their personality. But there are other schools of thoughts that maintain that mere labor in producing a work is not enough for making it copyrightable. The other key word comes into play: ingenuity. Ingenuity is essential because of two reasons. A. According to the incentive theory of intellectual property rights, including copyright, is an incentive for intellectual work carried on by the author of a given work to make a certain work. Copying a certain work cannot be the intellectual work envisaged by the theory. B. Doing away with ingenuity to promote copying or plagiarism or piracy, giving rise to free riding, again devaluing a product of real intellectual work, and as the object of intellectual property law is to promote the progress of science and useful arts, copying and free riding goes against the very spirit of intellectual property law.